Good afternoon. I would like to welcome you to a St. Thomas University event. And to lead us and start us off in this event, I introduce you to our president, President David A. Armstrong, JD.
Thank you so much, Dean Lawson. And obviously we are in very interesting times here, in difficult times and turbulent times. Anyone that obviously has seen the video of the passing of George Floyd, greatly disturbing, obviously. And for me personally, as someone who was a former assistant to the prosecutor while in law school, had over 70 trials, normally I don't like to make opinions based on videos on social media because they can be altered and doctored and things like that. But after seeing that horrific incident, I came out swiftly and quickly and asked for the prosecution, demanded the prosecution of the police officer involved and the police officers involved, because it is horrifying to see what happened at that moment. But now, as we're all dealing with the passions and the emotions and the protests and everything that we have, eventually we have to get down to the law and the facts. And I want to thank Dean Lawson for putting this webinar together for our law students and for our legal community and for anyone that wants to attend today to learn, and you're going to learn from the best. Dean Lawson is a former prosecutor, the legendary former Dean Al Garcia, wonderful prosecutor, the legendary Jay Silver, and one of our new professors, Donald Tibbs. I'm so excited I'll be on this whole webinar to hear the legal aspects that we are all now going to face. And the tough part is the emotions and the passions, not to set aside, obviously they're so important, but now we have to look at the legal side. And I think that this panel is really going to provide us the expertise that we all need to be educated on what's going forward. And so again, I just want to thank Dean Lawson, St. Thomas University Law School, all our faculty for being engaged and being a part of this. In the end, with all that we're dealing with, I believe the answer comes through education and faith to end racism, for us to respect humanity and love each other. And it does come down to that word. And I know that may sound pithy to some people, but I don't believe it is. Because education and faith and love will lead to action. And I, again, so appreciate our law school for stepping forward and our dean and our faculty stepping forward today to educate us on the legal aspects of this case. So God bless you, good luck, and I look forward to the rest of the webinar.
Thank you, President Armstrong. Yes, the law school is very active in this area, and I'm happy to welcome all the attendees today to our first lecture in a series of lectures and a symposia issue, two symposias hosted by the Intercultural Human Rights Law Review and St. Thomas Law Review. Those law reviews are going to be accepting papers from students as well as professors across the country to analyze these important issues. I want to welcome our expert panel. I don't want to spend a lot of time on their bios and all of their accomplishments, but suffice it to say, these are the leaders in the nation on these issues. Casebook authors of criminal procedure and criminal law on various topics, all of which surround this case. We've heard about the case in the media, but oftentimes those reports don't have the ability to go into depth as it relates to the specifics of the charges and the details of the statutes and all the things that prosecutors and defense attorneys will deal with as it relates to this specific case, which actually includes several different cases and several different charges. As we start off the discussion, some might say, where do we start? And I would say, let's start with the facts. How did this case begin? The facts of this case, based on the police reports, begins when George Floyd is in a convenience store, and there's a alleged $20 bill, counterfeit $20 bill that was used to purchase cigarettes. The owners of that store called the police, and the police began to investigate that issue. By the time the police arrived, George Floyd was not in the store. He was in his car nearby the store, and the car was occupied by 2 other passengers in the car. The police pursued that car and got George Floyd out of the car at gunpoint and pursued to arrest him based on these alleged facts. I'm going to ask the panelists to pick up from there, because it's somewhere after this point that is the genesis of now criminal allegations against the various police officers that were at that scene. And we have criminal procedure professors here too. And so before an arrest ever occurs, I want to ask our criminal procedure experts, is there a particular standard, factual standard, evidentiary standard that must be met in order to effectuate a lawful arrest?
Yes, go ahead, Don.
Hi, Tamara, and Dean Lawson, thank you so much for organizing this. I'm really excited to be here, and thank you for your kind words in opening President Armstrong. The easy answer to that question is yes, there is a legal standard that is required before the police can effectuate arrests, and that legal standard is one known as probable cause. And essentially what probable cause requires is that the police officers must be able to demonstrate effectively that there's a fair probability that a crime has taken place by the individual that they intend to effectuate an arrest against. It seems to me, in my opinion, having had an opportunity to look at the facts, to the degree that there was identified an individual who that we now know as George Floyd was in that had allegedly passed a counterfeit $20 bill. The way that the sort of charging documents read is that it was identified as a person who might be parked in a car around the corner. I'm not exactly sure from the charging documents themselves how they arrived at the decision that George Floyd was the individual that they were looking for. And even if it was, there still didn't seem to be enough probable cause to actually arrest him. The car was parked, so they couldn't use a moving violation. They would have to identify that he was the individual that they felt it was more probable than not, or highly probable or highly likely. There's so many different ways to sort of discuss the standard, that he was the individual who passed the alleged counterfeit $20 bill. We haven't heard very much about that as to whether or not he was adequately or accurately identified, but the police were able to move forward from there. And of course, there could have been any events regarding the interaction that might have gave rise to the officers to at least perhaps maybe have reasonable suspicion that he was the individual, but reasonable suspicion is not enough to effectuate an arrest.
Thank you. And I asked the rest of the panelists to also chime in on the issue of, you said there's a charge that they were investigating at that point. And to get probable cause, we look at what are the elements of that offense. So if the offense is counterfeit, possession and or transacting a counterfeit bill, under the statutes of Minnesota, that offense requires intent to defraud as well as knowledge that the bill is counterfeit. Was there any evidence in this case as it relates to that, or sufficient evidence against this probable cause standard? Do we have anything in the police reports, or anyone want to weigh in on that? Professor Garcia?
I haven't seen anything to that effect. I'm not quite sure, but elaborating on Professor Tibbs' point on probable cause is a fairly low threshold. Like he said, it's fair probability, which is a much lower threshold than the preponderance of the evidence, more likely than not. So the police really don't have to establish a high threshold of proof in order to effectuate an arrest. Now, of course, there's two ways that you can effectuate an arrest. That's based on the information that, in this case, was provided to the police, or alternatively, a more foolproof way is to seek an arrest warrant from a magistrate. So in this case, what you have is obviously the allegation by the store owner that the bill was counterfeit. In terms of the intent, because probable cause is such a low threshold, that's more of a matter of proof in order to file formal charges, or of course then subsequently prosecute the individual, because you have to establish proof beyond a reasonable doubt for a conviction.
I think what's interesting here, if I can chime in, can you hear me?
Yes.
Is that probable cause may or may not have been present in the arrest of the black man, but in the arrest of, for example, George Zimmerman, where there was clear probable cause. What is you've got a smoking gun there, and you've got a smoking gun with regard to Officer Chauvin. I mean, you've got a video of something that looks, anyway, and certainly passes the probable cause test of deadly police brutality, yet no arrest. So we see blacks subject to what may or may not be probable cause and getting arrested, and whites where there is pretty clearly probable cause not being arrested. So I think there's a racial disparity there.
So we would need probably more information. Maybe it's forthcoming from the police department as it relates to the part of their investigation that went to the intent to defraud and knowledge that the bill was counterfeit. It's my understanding that there are several counterfeit bills in circulation, in the normal circulation of the currency, and even an ATM machine can issue a counterfeit bill. So that's an issue of fact that the police would have to investigate to support an arrest for counterfeiting. So that's how our case starts out, based on an alleged offense in this convenience store, an alleged offense of counterfeiting, and an arrest. We can, debate further whether the arrest was appropriately supported by probable cause. Are there any constitutional issues that surround whether this arrest, in the way it was effectuated, was lawful? Meaning the use or manner in the way the arrest took place.
Well, Dean Lawson, once again, my reading of the document, the charging document, if I was sitting on the other side of the table and presumptively George Floyd had lived through this, there would have been a lot of issues that I could have raised with the way that the police sort of performed their duty in the context of the arrest. I mean, first of all, there is a question as to whether or not he is the alleged suspect. Then there's a question as to whether or not there was probable cause. But then there were also some really interesting facts about how the police approached the vehicle and spoke to him through the car, and then drew their gun on him while he was still sitting in the car until he put his hands on the steering wheel, and then they holstered their gun and then removed him from the vehicle. And at the moment that they removed him from the vehicle, they handcuffed him. So that handcuffing itself constitutionally is an arrest. It is being taken into police custody, which at that moment, before they can ask him any questions, they have to read him his Fifth Amendment Miranda rights before they can interrogate him. So it seems to be that there would ultimately, even if the events had not turned out this way, been a lot of constitutional concerns regarding violations that the police might have taken in terms of effectuating this arrest. They're authorized, obviously, to have him exit the vehicle. They're also authorized to restrain him. But the moment they handcuff him, the whole nature and tenor of the interaction, constitutionally, from a constitutional standpoint, changes. So there is, once again, it seems to be that we shouldn't be surprised knowing how things turned out on the back end, that there seems to be some missteps, perhaps in terms of training and the ability for the police to understand exactly which sort of procedures they need to follow in order to check all the boxes to not violate citizens, and in this case, George Floyd's constitutional rights.
So these officers were responding to, I think it's fair to say, a non-violent case as it was initially reported to them. So what would be the basis, or is it constitutionally valid to interact with a suspect, in this case George Floyd, at gunpoint, asking him at gunpoint to come out? Like the officers, the police reports indicate that they drew their guns at that early point. Is that constitutionally valid?
I mean, it's not.
Or allowed?
Well, there's nothing to indicate or to reflect that George Floyd threatened the police officers with any type of force or any type of imminent danger. So why they felt the need to pull their guns at that point is really puzzling, because short of him threatening the officers with any type of force, and certainly he didn't threaten the officers with anything approximating deadly force, there's no need for them to draw their guns at that point. Now, they may have done that. There's where the bias would come into play. Why would they have drawn a gun in this circumstance had the suspect not been black? And you query that, because there's nothing that reflects that George Floyd threatened the officers with any type of force, much less any type of deadly force requiring guns drawn at that point. Whether that constitutes a constitutional violation goes back to the issue that Professor Tibbs raised, and that is, if they did not have probable cause and a reasonable officer would not have believed, and here's where the complicated issue of qualified immunity comes into play. If a police officer under the circumstances would not have had a reasonable probability to believe that he or she had probable cause to effect the arrest, then that might constitute a violation of Mr. Floyd's constitutional rights at that point.
So are you saying that at that point, potentially, depending on how the analysis goes, that the officer was in violation of his authority under the color of law, and he was going outside of what his duties would allow? And
that is correct.
And if that happens, that's where he would lose any kind of protection of qualified immunity as an officer.
He would lose qualified immunity as an officer in a civil suit under 1983. Now, let me raise a distinction here, because this will come into play later into the discussion. There are two federal violations when, under a color of law, a police officer violates someone's constitutional rights. Under 18 U.S.C. 1983, the municipality can be held liable, and the police officer as well, unless he or she has qualified immunity, standard that I previously alluded to. Then the municipality would be liable for damages for violation of those civil rights. Now, there's a counterpart that levels criminal violations for civil rights violation. That's 18 U.S.C. 242. And so that imposes liability on the police officer criminally for the violation of a suspect's constitutional, or I should say here, a person, not a suspect, or they deem them a suspect, for violation of a person's constitutional rights. Now here, obviously, would be the use of deadly force resulting in death. So if you look at it from that standpoint, 1842 USC, if someone dies while the person is violating his or her constitutional rights, the penalty is severe under 242. Life imprisonment, and the statute authorizes the death penalty, which is seldom, if ever, imposed at the federal level. But the penalties are severe under 18 USC 242. I'm sorry, it was a lengthy analysis, but I figured that this was going to come into play later in the conversation. I figured I'd bring it out at this point.
Well, thank you, Professor. That's really important. And I'll come to you in 1 second, Professor Tibbs. I just wanted for the audience to just bullet the types of liability that have already been identified by the faculty. That we may have criminal liability that has been discussed a lot in the news, and we're going to get to that based on the statutes in Minnesota. Then we might have criminal liability based on federal statutes, and we might have civil liability based on civil rights violations also from our federal statutes. And these are issues that we would have to walk through and analyze, and our panel is well prepared to discuss all of those today. Professor Tibbs, you wanted to add?
Yes, I wanted to just double back to the use of force question from a constitutional perspective, because I think it's important that people understand that there is a real legal standard out there that the police are not just allowed to use force based on how they feel it's necessary to effectuate force. That the Supreme Court has been very clear in 1989 in the Graham versus Connor case that to look at, when you're looking at a use of force in the context of the Fourth Amendment, which in this case, we certainly do have the Fourth Amendment being applying to the seizure of George Floyd by the police officers, whether it be in handcuffs or at gunpoint. The Supreme Court has said that the use of force it must still be reasonable. And that measurement for reasonableness is going to be based on three main factors, right? One of which is what's the severity of the crime at issue. So in this case, we're talking about a counterfeit bill, alleged counterfeit bill. The other thing is whether or not the suspect actually poses an immediate threat to the safety of the officers, which we know George Floyd did not. And then the final measurement is whether or not the alleged suspect is actively resisting or attempting to evade, which George Floyd also was not. So it seems to me that the amount of force that the police use, not only in terms of drawing their handguns, but then in terms of subduing him and handcuffing him, violates the Fourth Amendment and violates the use of force standards as measured by the Supreme Court from a constitutional perspective.
And my understanding is, as an epilogue to the arrest, is that one of the officers reported that the use of force in this case to immobilize Mr. Floyd was that he had resisted arrest, which is, in my experience, a very common ploy, whether there was any resistance or not, to justify the brutalization of somebody who's been taken into custody and often is not resisting. This is.
Well, I think that's a great point, Professor Silver. So I want to circle around that really quick. So if he was, Professor Tibbs, at some point resisting early in this investigation, once the handcuffs are on, does the standard change? Is there a different analysis as to what type of force officers can use at that point once they've secured the suspect, in this case George Floyd, with handcuffs?
Well, yes, it does. Actually, once the handcuffs go on, the officers are almost required, both by the Constitution as well as their own training, to de-escalate. So in other words, there's no there's no authorization for them to continue to use force in a certain manner, and there certainly there's no authorization for the use of deadly force. So the force can only be used from the perspective of subduing the suspect. Once the suspect is subdued, then the level of force that is authorized by the police diminishes significantly, because essentially they're in control. Essentially, they are not in a situation where they're in danger, or they're not in a situation where he is going to flee. So once Mr. Floyd was subdued, it seems to me that the officers holding him down on his legs, pinning him down by his back, and certainly pinning him down by his knee, with a knee to his neck, even just to hold him to presumptively, if he did not die, would still be an excessive use of force from a constitutional perspective.
So I want to move us a little factually in the scenario. We've seen on the video, and I just want to note for the audience, I don't believe that's the only video in this case. It's the video, as President Armstrong noted, that was posted on social media and gained attention to this case. But there is other official police video that no one has seen except, government agents, as I understand it. So we still have evidence that we don't know about. But from what we have been able to see, we later see George Floyd on the ground, handcuffed. Can we maybe pick up our analysis there of what you were talking about, Professor Tibbs? Is there anything unconstitutional when you're talking about Graham versus Connor and the reasonable use of force in that scenario?
I mean, I think once he's on the ground and he's handcuffed, it is the officer's responsibility then to, not only they have a responsibility to him to protect his life, because certainly he's under their care, custody, and control at that point, but it's incumbent upon them to get him to a safe space, certainly because he has been subdued by the police. So, it's interesting that there's been some issues about whether or not they could get him in the car, or whether or not he wanted to go into the car. It's my understanding that he may have suffered from some psychological concerns regarding being in closed spaces. But we're not really sure, because we haven't really been able to see all of the video from the police, which in and of itself is problematic, right? Which is that the government is holding on to evidence so that they can go through it and then sort of construct a narrative that should be actually authorized to the citizens to be able to see. So once he's subdued, once he's on the ground, and he no longer poses a threat to him, it's their responsibility to him, from both a criminal law perspective and also from a civil perspective, from a tort perspective, right, to actually get him and escort him into the vehicle as quickly as possible. At the very least, if they are struggling to get him into the vehicle, they could certainly have just had him sit on the side of the road. He's not going anywhere. He's surrounded by 4 police officers. They all have guns. He has none. They have him in handcuffs. He can outrun them. So it seems that the use of force beyond that was more intentional in terms of inflicting harm and pain upon him than it was for sort of protecting his life and placing the duty of care upon them to take care of him and protect him and to make sure that no harm occurred to him.
Okay, I'm going to put a footnote on intentional, because we're going to come back to talk a lot about mens rea, which is at the core of any criminal charge, and the charges of these officers and the multiple counts and theories. Was there intentionality as defined by the murder statutes in Minnesota and the various counts? But I wanted to let Professor Garcia and Silver weigh in at all about the use of force at the point that George Floyd is on the ground handcuffed, from a constitutional perspective, legal perspective.
Oh, I agree with Professor Tibbs. I think the use of force in this case, and just from a tactical, strategic training perspective, you only use force in a proportional manner to the degree that you need to use force. not to exceed the amount of force you need to use to subdue the suspect. And it is evident and patently clear that they exceeded by any stretch of the imagination the force that they needed in order to subdue the suspect. The suspect was more than subdued. I mean, I think that Professor Tibbs put it well. I think the force being used was clearly disproportionate.
You're only allowed to use excessive deadly force if that's what you reasonably believe you're facing. There certainly was no reasonable belief that at that point, in handcuffs, face down on the road, officers around, that he posed any reasonable risk of death or great bodily harm to them.
So we know what happens next from the video, and it's very graphic. Many of us have seen it. There are in time where George Floyd says, "I can't breathe." He says, "I'm going to die," and things of that nature. Was there any, at that point, does the constitutional obligation change when the suspect is saying those kind of things? Or is there something more that we could add to the analysis based on that fact?
I mean, I mean, at that moment, and this may very well speak to Professor Garcia's point, at least for me, at that moment where one of the things we're really clear about with criminal law is that you can understand the state of mind. I'm setting up the mens rea right now. You can understand the state of mind from an individual based upon the words that they're actually speaking. And in this situation, the fact that he's saying, "I can't breathe, please help me, I'm going to die, oh, please, mama, help me," like those words in and of themselves basically put the officers on notice that the force that they're using constitutionally may be deemed as excessive. Add to the fact that you have bystanders saying, "Hey, he can't breathe, like he's losing his life." It seems to me from a constitutional perspective, the reasonableness, they breached the reasonableness standard up for an officer that's under Graham versus Connor, and in fact, I think crossed into the sort of section 1983 liability point where they're actually operating outside of the color of law.
I think this transitions us into the actual charges that follow, but I will put a footnote on the term that you used, bystanders. And in criminal law, I will ask our experts later in the panel, is there any liability, criminal liability, that flows to bystanders, and even maybe tort liability that could flow to bystanders? But we know that there were criminal charges that followed this incident. Prior to the criminal charges, the officers were terminated by their police department. And then subsequently, these former officers were charged criminally. And I wanted to shift our discussion to look at those charges and ask the larger question, are these charges sufficient? Are these charges appropriate? What are these charges? We do have, I'll ask our assistants that are helping us behind the scenes to post, share the screen to show criminal complaint number 2, which is the actual document of the charges in this case. So currently, and we know through the media that there was an original criminal complaint, and this was the second amended. We have a second-degree murder count, unintentionally while committing a felony. We have a third-degree murder count, perpetuating an imminently dangerous act, and depraved mind. And we have the third count, which is a second-degree manslaughter, charging culpable negligence. So I know I have experts on the panel as it relates to mens rea, as it relates to, and attached to the charges is a statement of probable cause, which basically we've gone through most of those facts already. So I just wanted to share the screen so the audience would know we're going with specific facts and filed charges already that exist in this case. And we can take those off the screen for now. Thank you. And I'll ask the panelists, are these sufficient charges? Are these the appropriate charges? Are these charges that the prosecution can prove their case on?
I think clearly they can prove the charge. What's somewhat baffling and puzzling is that the primary charge, which is second-degree murder, is via the application of the felony murder doctrine, which in essence states that if someone dies during the commission of the felony, then the underlying felony is the predicate for the charge. And if you look at the charging document, the criminal complaint, you can see that they don't have to prove intent to kill. It's unintentional. It's felony murder via the application. It's second-degree murder via application of the commission of the felony. And it seems to me that given the facts, you could probably make a case that they could establish that the murder in this case was clearly intentional. Now, you might say that it's a little bit easier perhaps to establish the second-degree murder charge through the application of the felony murder doctrine, or alternatively, what some prosecutors do is they charge the intentional murder and they use the felony murder doctrine as a backstop. That is to say, they tell the jury you can find the defendant guilty of second-degree murder via two ways: by establishing that he intended to commit the murder, or if you don't find that he did, then you apply the felony murder doctrine to achieve, in essence, the same result. So the question too here is, could they have charged first-degree murder, which requires premeditation and deliberation before the killing? One can make the argument that, going back to the earlier facts, that when someone is telling you that they can't breathe, when they're asking for their mom, when it's such a prolonged period of time, that certainly there's plenty of time for deliberation and premeditation of that murder. You don't need a long period of time in order to premeditate or deliberate. Now, a quirk in the state of Minnesota is that if you are going to charge first-degree murder, you have to seek the indictment of a grand jury. That is to say, the prosecutor can't just file a criminal complaint in lieu of seeking a grand jury indictment. By the way, Florida is also similar, but they call it here an information versus a complaint filed by the prosecutor. I may add a little footnote. The Minnesota prosecutors face a stream of criticism because a lot of times in police-involved killings, they would seek grand jury indictments and thereby exonerate themselves from any criticism by saying, well, we sought a grand jury indictment and the grand jury refused to indict. That changed with the Blando Castile case, where in lieu of seeking a grand jury indictment, they filed a criminal complaint by saying, we didn't rely on a grand jury in this case to formally charge the defendant with the crime, but rather we made the decision ourselves. So these are the various scenarios involved in this. And I might also add that the punishments under the Minnesota criminal sentencing guidelines are quite different in terms of first-degree murder charge, in which you're looking at life imprisonment, versus a second-degree murder charge, where the sentencing guidelines, which bind the judge unless he or she says that there are aggravating circumstances warranting a departure from the guidelines, call for an average of about 20 years in jail, 2/3 of which would be served. The rest would be under supervised release, which means if convicted, the defendant would only serve roughly a little bit less than 20 years in jail. The rest would be served under supervised release. And if under a third-degree murder charge, which was the original charge, you're looking at 150 months or less than 8.5 years that the defendant would serve in prison. So you've got a lot of disparity at the state level, at any rate, in terms of the potential punishment for this.
You mentioned, Professor, the difference earlier of the state and the federal, and we have a question from the audience asking why hasn't the former officer been charged federally?
That is a very good question. Now, let me back up on this. The Supreme Court just this last term in the Gamble case reaffirmed that, and now some people in the audiences may be wondering, well, I thought double jeopardy prevented someone being charged and convicted for the same offense. There's an exception to the double jeopardy doctrine called the separate sovereign doctrine, which says that if you have two separate sovereigns, it doesn't constitute double jeopardy. That is to say, you can get convicted by the state and you can get convicted and sentenced by the federal government because they are separate sovereigns. So that doesn't really prevent the prosecution. Now, at the federal level, because of that double jeopardy issue, there is a Justice Department policy called the Petite policy. And that policy basically says that because even though the feds can also charge and punish under a different statute, but for the same transaction or the same offense, federal prosecutors, after the state initiates criminal charges, must seek permission from the Assistant Attorney General before they can file federal charges. I think from a pragmatic or practical perspective, typically the federal government will probably wait to see perhaps what the outcome of the state charges is before they go up that level. So no prosecutor, federal prosecutor on their own can seek an indictment before they go up the chain pursuant to this policy and seek special permission from the number 2 person in the Justice Department, that is to say, the Assistant Attorney General. There are a lot of complicated issues here with respect to that. Now, for those of you who remember the Rodney King case, what occurred in that case was the police officers who were viewed on video assaulting Mr. King were acquitted by a state jury of the state charges. The federal government then filed the federal criminal civil rights violation and obtained a conviction in the Coons case at the federal level. And again, double jeopardy didn't prevent that or preclude that, because obviously, even though the police officers were acquitted for the same transaction at the state level, they were subsequently convicted and served prison time when the federal government filed charges pursuant to the federal criminal civil rights violation statute, 18 U.S.C. 242.
Well, thank you, Professor Garcia. This raises a lot of issues that circle around the complicated matter of the prosecutor's discretion in charging the case, and now, as you outlined, multiple prosecutors' discretion in what is the appropriate charge and what is the sufficient charge. Bringing in the issue of the grand jury is also important to the analysis. In prior cases, we have seen grand jury presentments. In the Michael Brown case, where the grand jury returned a no bill, and in the Eric Garner case, also grand jury presentment, and the grand jury returned a no bill. So it sounds as though the panel is sharing that another strategy or another tool in the prosecutor's toolbox is to charge an offense that does not require a grand jury indictment, and instead charge an offense here in the state of Minnesota that is within their discretion to charge by complaint. So also, but what goes into their, oh, go ahead, Professor Silver.
I'm sorry, I see it a bit differently, perhaps because I was a criminal defense attorney, but there is an old adage, of course, that the prosecutor can get a grand jury to indict a ham sandwich if they want. I don't know if that applies to corned beef or any other, but that's and which suggests that it did not want to get, it wanted to shift the burden of not charging in Ferguson, Missouri, and with Mr. Brown at Staten Island, and it sort of shifted the burden of that decision not to charge, although it manipulated that decision, to the grand jury, and that it can just as easily get the grand jury to return a murder indictment, murder one. And I just wanted to throw that in. And as far as the feds stepping in, my understanding is typically they will step in more often when the state fails to act.
Yes.
It's a safety net. Yeah.
Well, Professor Silver, now I have to just share, to balance the discussion, why a prosecutor would want to go to the grand jury as opposed to charging on his or her own discretion. The case, if we're talking about a real criminal case, will ultimately go to a full jury. And if a grand jury, just as you said, is so inclined and beneficial to the prosecutor, is not willing to find any truth in the charge, maybe the full jury, the petit jury, won't find it either. And this is a way to learn if this case is strong enough to be charged at all.
There certainly is a problem if the prosecutor can't get the grand jury to indict, because the standard that they're looking for at the indictment level is different and much lower than the standard they're looking for at the trial and conviction level when trying to speak to, a petit jury. But, it seems to me that we're also sort of dancing a little bit around another sort of topic that I think we should probably be discussing, which is, why does it seem to be that these prosecutors are sort of patently and consistently failing at their ability to hold police officers accountable in cases where it would seem the conviction should be obvious, both from a grand jury and a petit jury perspective? I mean, for the inability to be successful in the Rodney King case, the inability to be successful in the Michael Brown killing, with Darren Wilson. And I took the time to actually read the entire transcript, and it just seems to me that there were questions in the Darren Wilson case where the prosecutors took their foot off of the pedal and just failed to follow up with certain questions that would have just led to a really easy standard of probable cause. But I mean, it's also hard to understand how you don't find and meet the standard for probable cause that someone committed a homicide when the person says, I committed a homicide. And so, you know, I mean, you have the police officer saying, yes, I committed this homicide. That in and of itself is enough to rise to the level for the probable cause. That might not get you to a conviction at the petit jury standard, but it certainly shouldn't prevent us from being able to see these officers being charged. And it seems to reek over and over again of a prosecution sort of tepidness with dealing with prosecuting police officers, primarily because of their professional interactions together. I mean, we just saw that play out in the Ahmaud Arbery case, where the prosecutor said, I can't be on this case because I used to work with this police officer who's now retired. And so I'm not going to do anything to assist in charging him at all. So I want, you know, just to, in terms of like not shifting the conversation, but making sure that, you know, we shift the conversation to accountability for prosecutors to represent the people, you know, to the degree that we are the people and it's their responsibility to hold us accountable for our crimes. It's also their responsibility to hold police officers accountable for their crimes, but they seem to be sort of consistently tripping over themselves in this moment. And the real irony, I think, in all of that is simply because they're not successful at it. And the reason they're not successful at it, I think should really raise questions about the standards of practice. I mean, I think it should raise questions about whether or not these prosecutors are, once again, taking their foot off the pedal when they should, whether there's a politics at play here. I mean, there's a lot going on, but we just shouldn't even be concerning ourselves about whether or not these indictments should go through. There should be no question about an indictment against Derek Chauvin. I mean, that seems to be obvious. I mean, and I think if it was any other citizen and you had that kind of videotape, the prosecution would go to indictment and probably charge with a first-degree homicide right off the top.
And I'd like to point out, I'd like to pursue that. I think in addition to there being institutional racism with regard to the prosecution of white officers who brutalize African Americans, there's a complicating factor. There's a structural conflict of interest built into the system when you expect prosecutors to charge police for brutality. Incidents of brutality, they're interdependent members of the same vocational family. The job of the police is to aid the job of the prosecutors, gathering all the evidence to put the bad guys away. Each needs each wants and needs smooth working relations with the other. Well, when one starts charging the other with murder, that can break down those smooth relations. What's the solution? The only thing I can think of is when there are charges of police brutality, that those charges should go to an independent investigatory agency and an independent prosecutor that has no relationship, no affiliation with the prosecution in the venue of the alleged crime or with those prosecutors there.
Yeah, and if I may add on to that just very briefly, Professor Silver's incisive comments. He's right. Judge was supposed to have said that a grand jury can indict a ham sandwich. And the reason for that is it's a secret ex parte proceeding controlled exclusively by the prosecutor. So, and 93% of cases presented to the grand jury result in indictments. Mm-hmm. Why? Because the prosecutor controls the grand jury.
These are excellent points about grand jury presentments of recent note on other cases of police brutality, particularly the Michael Brown case had several alleged incidents of error in the law, in the instruction to the grand jury that was at one point corrected, but maybe tainted their view because they were given the wrong law at one earlier point, or the amount of evidence that should be given at an early stage in the case when the standard is only probable cause. That was another allegation in that particular grand jury presentment. So there is a lot pending on how the prosecutor exercises his or her authority in bringing these charges, and is it appropriate? And are they using all the same resources they would use in any other case? Professor Garcia, you mentioned earlier, and we have a question going to that. You mentioned the difference in the Rodney King case. There is a question from the audience asking about venue. The Rodney King case, presented a venue issue, and this audience is asking, is there going to be a venue issue here? Is it possible that the defense may request to change the venue of this case?
Yes, and let me add that obviously there was a change of venue in the to Simi Valley. In fact, I was in Los Angeles, working in Los Angeles at the time that the Rodney King case was brought to trial. And obviously, Los Angeles County is a very diverse county where the state case was tried in Simi Valley. It wasn't a very diverse county, so therefore the jury pool of Van Nuys was practically homogeneous, which contributed to the acquittal or the not guilty verdict. The interesting part about Minnesota is the following. There are 87 counties in the state of Minnesota. There are 2 counties where the African-American population is greater than 10%. One of which is Hennepin County, which is Minneapolis, which has a 13.6% African-American population. 13.6% of the population is African-American. Wright County, which is the adjoining county to Hennepin County, has an African-American population of 1%, and 47 counties out of the 87 counties in the state of Minnesota have African-American populations of less than 1%. So in this case, in order to get anything resembling a diverse jury pool, it probably would be more fair and just to try the case in Minneapolis itself. Now, the defense will probably changes of venues are extremely rare, rarely granted, because the Constitution and the Sixth Amendment basically say that the case should be tried where the crime occurs, unless you cannot get a fair and impartial jury, obviously because of prejudicial pretrial publicity or a host of other factors. Now here, there's no one in the United States and or abroad that hasn't heard, unfortunately and tragically, of the George Floyd case. So it's not like everyone has been exposed to this and has probably seen the video, obviously. But you can say, well, maybe in this case, we need to move the venue. If you do move the venue, then you risk the possibility that you will not get a diverse jury pool. Rather, you will get a homogeneous pool because of the racial and ethnic composition of the state of Minnesota. It's very interesting. Now, there are variations to this theme. For example, in the Casey Anthony case, crime occurred in Orlando. It was tried in Orlando, but the Van Nuys was selected from a different county in the state of Florida, not from the county where the crime occurred. So it'll be very interesting to see if there isn't a plea in this case, and if the case is not resolved via plea, whether the defense will ask for a change of venue from Hennepin County and Minneapolis. And if so, what, if any, counter arguments the prosecution will lodge to oppose the change of venue. And I would presume that one of those arguments will be precisely that, if you shift the venue, then you risk selecting a venire that is virtually homogeneous.
I want to add into our discussion, they're not just charges of the main officer. There were other officers on the scene. Is there any criminal liability or other liability for those officers? And what is their liability?
You want me to take that, or?
Well,
Oh, okay. All right. There's accomplice liability for the other three officers. They've been charged with second-degree murder as accomplices. And basically, an accomplice is someone who, in the common parlance, aids and abets the primary crime. That is to say, the person assists the primary actor in committing the crime. Now, the interesting aspect of this case is that the other three officers obviously stood by and did nothing while Officer Chauvin was, in essence, killing George Floyd. So, well, you know, if that would have been the common law says, well, you can't charge anyone just because they don't intervene and they're silent. Here, it's different because you have a police officer who has a duty to prevent a crime from being committed literally before their eyes, who does nothing while the crime is occurring. So the law does have an exception built into it for accomplice liability, where people have a special duty. And in this case, the three police officers being charged with second-degree murder via accomplice liability had a duty to prevent the death of George Floyd.
Yeah, I feel Al is exactly right. That the case against them is very good. The accomplice, they actively, I believe, participated in the crime. They weren't just standing there because they had nowhere else to be. They were standing there to protect Officer Chauvin as he was performing his the neck choke, and keeping the crowd, which was assembling and which was they worried would get unruly, away. This was active participation, protection of the person who's actually committing the murder, and I see them as a principle of the second degree. And I think there's another way you can characterize their participation: by omission. Police in Minneapolis, and Professor Tibbs knows this by heart, I think, they're bound by police rules to intervene when they see an abuse like this. And Minnesota happens to be one of the few states in the country that has a generalized duty to rescue, a generalized duty to provide help in an emergency situation. And so by violating those duties, that's a form of participation in what happened, allowing what happened to occur. So yeah, I see them, like Professor Garcia, clearly as people to whom this charge would apply.
The case against the other three officers, in my opinion, is really open and shut. And I completely agree with Professor Silver and Professor Garcia. This one should actually be a slam dunk by the prosecution. Not only do you have the accomplice liability where they're actively involved and participating in the crime, but then there's also, as Professor Silver said, the duty to intervene and the duty, the failure to intervene through the omission. You know, it's very clear, and I just want to make sure that everyone knows this, that the police manual in Minnesota under which they are trained has a section in it. And I always try to teach my students, read the code, read the statutes, read the sections, because it will answer all the questions for you. It has a section in it, section 5-303.01, called duty to intervene. And I'm going to read the language to you so that you know exactly what the officers were trained on by their own policemen. It says, and I quote, "It shall be the duty of every sworn employee present at any scene where physical force is being applied to either stop or attempt to stop another sworn employee when force is being inappropriately applied or is no longer required." That in the police manual is going to make this really an open and shut scenario, because they had this duty to intervene. They knew it. They even tried to activate it by asking Chauvin, should we roll him on his side? So that shows that they're aware, that shows that they have knowledge, that shows that they understand the situation. And I just want to point out that one of the officers' attorney has actually raised the argument, well, why didn't the public intervene and push these officers off of Mr. Floyd? Okay, so that's a great example of a bad attorney, simply who doesn't understand how policing and citizens work together or work against each other. To interfere with a police officer while they are performing their duties, official duties, is a felony. It is considered a felony when you intervene with a police officer as a citizen. You are, number one, obstructing justice. Number two, if you touch an officer while they're trying to make an arrest, that's a felony assault on an officer. So essentially what this attorney is arguing is that instead of his clients doing what they should have done, the citizens and the bystanders, the people on the street, should have accepted taking a felony against themselves in order to stop Officer Chauvin, who had a duty not to kill Mr. Floyd in the first place. So I think the case against these other three officers is really going to be very open and shut. I don't even think, I'm surprised that they haven't gone on ahead and accepted a plea deal at this point.
I think we're also circling around the issue of the police department.
Mm-hmm.
And whether this police department is operating appropriately. And I would ask our assistants to put up the human rights complaint. And so in Minnesota, this has been formally alleged and is being looked into as a human rights violation of racial discrimination. So the Minnesota Human Rights, yeah, there we have it. The Minnesota Department of Human Rights has alleged a charge of discrimination against the police department. And yes, they're asking to investigate this incident that resulted in the death of George Floyd, but they're also asking to investigate the police department for all incidents, several incidents that predate George Floyd's death, going back to January 1st, 2010, all the way to the present. They want to investigate those cases. They want to know more about the training, policies and practices of this police department. Is it adequate? Is it constitutionally appropriate? Is it in violation of the Minnesota Human Rights Act, as well as the criminal penal statutes, as well as we've mentioned the federal statutes. And then let's talk about that briefly. And then I want to also ask the panel, if we do have civil rights violations, who's responsible for bringing those? Right now, we see the government attorneys acting on behalf of the Floyd family and behalf of the larger community to seek some kind of redress to this conduct. But in a civil rights 1983 case, who brings that kind of case? So that's two areas I'd like to cover.
you can see that this human rights violation is really a notion that is not just unique to the United States, but obviously lies at the heart of justice and fairness and equity and equality. And I think that that's what the human rights charge really reflects. It's in essence almost equivalent to the international standard of a crime against humanity. So that's the human rights perspective. In terms of the federal civil rights, as I mentioned before, the statutes that impose both civil and criminal liability for violation of civil rights, constitutional rights under the color of law, are filed obviously by the Justice Department, and so by the federal government, and they're the ones that are responsible for filing. I'm sorry, I misspoke. For filing the federal criminal civil rights cause. Typically, it is in this case, it would be the survivors of Mr. Floyd who would file in federal court for relief under the federal civil rights statute, that is to say 1983. If these were federal officers, it would be a Vivens cause of action. It was a federal case, Vivens versus 6 unknown agents of the Federal Bureau of Investigation, that establishes the liability for federal officers. In this case, it was state officers, so 1983 would apply. And so it would be the family's attorneys, who are the survivors, who would file in federal court for violation of the federal civil rights, under federal civil rights civil relief, 1983. I might also add that some states have counterparts to the federal 1983 statute as well, but the bulk of the relief is sought under 1983. That's where the qualified immunity of police officers is concerned. And I did a study a long time ago on the success of 1983, and 1983 cases are rarely successful. And because of qualified immunity granted to police officers, most of them are dismissed at the summary judgment stage. And that is a deep problem with 1983. And there's some discussion now about perhaps reforming that through a bill.
I'm going to let the other professors jump in, but for the audience, I want to just highlight that when the panel is talking about civil rights 1983 claims, it is not only the actions of the police officers, but it also includes the actions of the police department. So their failure to train, their failure to supervise, their negligent hiring even, or keeping certain people on the job. There's in the facts of this case prior complaints against several of the officers that are involved in the killing of George Floyd. So all of those facts would be part of the torts brought in the civil rights context. And, we can also consider who is it that pays for those violations. Actually in our audience, one of our audience members even gave us the stats that the Minneapolis Police Department has settled in court up to $60.8 million worth of excessive force cases. That's not unusual. If you look at the statistics across the country, major cities have a lot of millions of dollars that are paid out in police misconduct cases, and this comes out of, taxpayer money. But anyway, would the other panelists like to opine on this topic where we are now?
Yes, my impression is that these problems with the Minneapolis Police Department are pretty universal across the country. That sort of institutional racism within each, if you look at the number of white officers patrolling black communities, there's a tremendous disparity. And there are really two different roles that police departments play. There are two different forms of policing. There are many. It lies across a spectrum. But to generalize, for example, you get the kind of police department in the poor minority communities that we occasionally see videos about, the horrific, unthinkable abuses. You don't get them out of affluent white communities. The police there perform a very, there is not this sort of occupying troop mentality or adversarial mentality. There, the police department functions almost as concierges to the residents of the more affluent white neighborhoods. You've got two very different forms of policing, which may contribute in its own small way to this notion among people in the sheltered white communities that oh, the police are harmless. Institutional racism is invisible to them in their day-to-day life, and that's my thinking.
There's just an overall, a general different expectation regarding how the police are going to take care of you if you are African American, if you're Black, versus if you're white. I mean, we've seen over and over again incidences of white Americans essentially activating the police force and weaponizing it against Black people as if it's their private security guards. I mean, we just saw that in the Cooper case in New York City, where the white woman basically called the police on Christian Cooper, who wasn't even doing anything, and her sort of sense is, I'm an African American man, and they're going to come and do something to you. And so there's this sort of, to speak to and to highlight on Professor Silver's point, there is a different experience and a different expectation, even to the degree where there's a little trepidation sometimes from the Black community to call the police on each other, certainly because we know that the outcome usually results in death or some type of different treatment that is escalated far beyond what it should actually be. This really speaks to the issue of the systemic racism that's present in policing that dates all the way back to slavery. I mean, the police force has been always and has continued to basically serve as an institution that is anti-Black, that treats people as if they are devoid, treats African Americans as if they are devoid of constitutional rights. Going back to Minnesota itself, let's take it back to the Philando Castile case. Here's an African American man who is a licensed gun owner and licensed to carry, yet he's killed for having a weapon on him and accused of pulling it, which he didn't even do. What about his Second Amendment rights, right? What about his constitutional validation? Where was the NRA to speak out on that particular case? So the presence of this sort of systemic racism and the way that the policing departments treat African Americans really, and it plays out in the cases also because it becomes difficult to obtain a conviction when the police officer is white and the victim is African American or Black or brown, and even more so if they are male, just simply because of the routinization of sort of treating the Black body as if it is something that is devoid of value and something that is devoid of constitutional rights. It's something that I refer to as deconstitutionalism. It is just treating Black people as not just as if we don't care, but as if we don't have the same constitutional rights as other citizens in this country. And the issue of who's going to pay for this is the taxpayers. we continuously, I want everyone to understand that there will be a civil lawsuit and it will be settled by the city of Minneapolis. And the money is going to be paid to George Floyd's family. Who's going to pay for that? It won't be the police officer, right? Because of the qualified immunity. It won't come out of their pension because of immunity. It comes out of the taxpayers. So essentially what's happening is that the taxpayers' money is being used to pay for their own brutality. And it becomes highlighted even more when you think about Black citizens paying their taxes in the same way as white citizens do, but paying for our brutality by the police. And so it's a really sort of twisted way of thinking and analyzing and recognizing how bad policing is in this country. And we not only have a systemic problem, but when you have a systemic problem, you need systemic change.
Professor Tibbs, related to the officer's duty to intervene and their behavior and how they've been trained, one of the questions asked, does it matter that one of the officers was a rookie officer? Does that affect the duty to intervene? Is there a lower standard for the rookie officer on the scene?
No. I mean, that's the easy answer to that. No, this officer is trained and he is licensed to do his job in the exact same way as any other officer. He doesn't receive a lower standard because he's been on the force a least amount of time. The standard applies to him the exact same way. I mean, as unfortunate as it is, I mean, I want everyone out there to think about how troubling this is when you consider you've been on the job for exactly 4 days and you're now facing 40 years in prison because you failed to do the thing that you were trained to do. You know, the ramifications of Derek Chauvin's actions are global. I mean, if we think about all that's happened around society in just these last 2 weeks, the protests, the amount of forces being used, the amount of expense involved to bring the military into the United States, not even whether or not it should not have been done, but just the actual costs associated with that, the harm, the psychological harm, the physical harm, the emotional harm, all of that stuff comes from one person doing one thing really bad and being supported by 3 other bad actors. And when you understand it and you think about it that way, you really realize how powerful, the real power of racism and our failure to deal with racism, the way that it can have such a huge detrimental effect on us nationally as a people, but also globally as a world.
And if I may add just one matter, my understanding is that, yes, officially these police officers were only 3 or 4 days on the job, but before that they served at least a 1-year apprenticeship before this occurred. So it's somewhat of a misnomer to label them quote unquote rookies. Let me also add another issue that I referred to earlier. We look here, and as the public, we look at the atypical case as the most egregious case, as the case in which obviously the municipality has to pay the damages for the 1983 violation. But we can't lose sight of the fact that because of the qualified immunity granted to police officers, most 1983 cases, okay, do not succeed. They do not succeed. And there's one case which went up to Supreme Court, the Anderson versus Creighton case, where an African-American family in a wrong house raid was taken out, humiliated, grabbed by their hair, a very upstanding family. You know what they got? 0. Why? Qualified immunity. So we tend to look at, as the public, at the atypical case, not the typical case in which the 1983 cause of action is filed and it does not succeed because of the qualified immunity being granted to the police officers. And so I don't want to lose sight of the fact that the bulk of 1983 cases fail. and they fail at the summary judgment level.
And
Just add before you say that, Jay, that the people who have to bear the cost of that failed case are the victims' families.
That's correct.
There's no free attorney to bring a Section 1983 case. So you have to get an attorney that you pay by the hour, or convince an attorney to take a contingency fee to file that case. And based on those statistics, Professor Garcia, a lot of attorneys don't want to take a case where there's no compensation, recovery of damages at the end of that case. So statistically, a lot of cases that are otherwise viable are not even filed in Section 1983 because it's such a hard burden to overcome to be successful.
I can tell you from personal experience that once I told potential clients what the likelihood is of successes in 1983 cases, they would say, don't bother. Okay, I get it. The likelihood is we're not going to win, so we'll walk
And there
away.
was a prior settlement in one of the officers' cases, actually. One of the officers involved in this George Floyd incident, Minneapolis had already paid out $25,000 in a prior case. Professor Silver?
Thanks. Yeah, I just wanted to remark on Professor Tibbs' insightful comments. That this has turned into, this short video has turned into a global issue, and all the tumult surrounding it. And if a 17-year-old girl didn't happen to have the courage to take this video and be in the place where to take this video, none of this would have happened. On the other hand, this is the tip of the iceberg. As many videos as there are and as regularly as they're coming out, they can only represent some small factor of some small fraction of the abuse. I don't know if you multiply it by 1,000, 100,000, whatever. But that's important to consider too. This is a very universal problem. This isn't Minneapolis's problem, just Minneapolis's problem. And also by the defense saying that, well, this officer was on the job for 4 days. No, they're not, I don't think they're suggesting that there's a different standard. I think they're playing to the sympathies of the jury. They want the jury, if there ever is one, to say, oh my, nobody's, that's too much pressure to put on somebody the fourth day to override somebody very senior. They'll be fired or they'll never progress in the organization. So I think that's just merely a defense strategy, not a legal position.
And I would just add something to your comment, Professor Silver, when you say this has become a global issue. Unfortunately, this has been a global issue for many years and decades. And I would just cite as proof of that, the brief that was filed before the United Nations by African Americans in 1951. It was famously entitled, "We Charge Genocide." And they were alleging some of the same issues that we're talking about here today. Police brutality was among the list of allegations in that brief, and alleging that the Black community, African Americans, were being targeted in America. It's a problem we have not yet solved.
I think another problem too, Dean Lawson, that we haven't solved is, you know, how do officers continue to maintain their ability to hold on to their employment status in light of all the complaints that are filed against them? What is it about the blue wall that's preventing them from being held accountable from inside the institution? What is it about the Serpico effect that's preventing them from whistleblowing on each other when they know they have bad actors amongst themselves? You know, I don't remember the exact number, but I know it was in the teens that Officer Chauvin had a multitude of complaints against him. And I'm pretty sure that if I had 15, 16 complaints against me in any job in this country, I wouldn't be allowed to maintain and stay in that job and certainly be in a supervisory status. So what is it about the institution of policing itself? What is it about the power of police unions to sort of use their ability, their political sway, whatever the case may be, to protect officers? And what is it about the power of policing where you have a job where you can constantly fail and never be held accountable for it? And what does it then mean about keeping those people on the police force who then train new officers all of their bad acts? And it just sort of continues to become a self-fulfilling prophecy when you have bad actors turning good actors into bad actors through their on-the-job training. And so it's clear to me that these other officers knew that something was wrong and knew that something should have been done. But what is it about the relationships that occur within the institution of policing that would prevent them from going over and pushing Officer Chauvin off, or even sort of suggesting to him more forcefully, we need to flip him over on the side? What is it about what would happen to them on the back end that makes them so afraid to do their job on the front end? And what does that mean for us as citizens as we come in contact when you have the supervisor as a bad actor and you have the good actors who are afraid to stand up to the supervisor? And then all of that is happening under the cloak of protection within the institution. And then all of that happening under the umbrella of immunity. And then all of that happening under a larger umbrella of prosecutors' inability to prosecute. And then perhaps even thinking about a larger triangle where you have prosecutors, police officers, and judges, right? There becomes a perfect triangle formed between the three of those individuals that makes it really difficult from the defense side to sort of get the justice that people need, even speaking back to the failure to succeed in Section 1983 cases.
I think that's a wonderful, wonderful overview. And I think it suggests why this is not a periodic personnel problem. This is why we call it an institutional racism. The institution's rotten with this.
Go ahead.
I was going to say, you keep seeing the comments regarding, well, he's just a bad apple. He's just a bad apple. I mean, I don't know a whole lot about fruit, but I know if you take one rotten apple and you stick it in a basket with a bunch of other good apples, they'll all start to rot around it. It will start to spread. So get rid of the bad apples. Like, why are you protecting them? They're making it worse for everybody, and even dragging down the name of the police department. I mean, to the degree that there are some good police officers, why are you being loyal to these individuals who are being disloyal to you, disloyal to your job, you know, disloyal to the thing that you want to do a good job? Why are you being loyal to them when they're showing you no loyalty and no respect at all and making it hard on everybody? I'm going to stop.
Okay. Well, a couple of things I think that are still circling around in the questions and the concern of a lot of people looking at this case. I want to get to the question of what reforms we might want to highlight should be on the forefront of the legislature in different jurisdictions. But before we get to that, is it possible for us to answer the question for the audience? Why is this not an intentional killing? They're concerned about the fact that there's 8 minutes, almost 9 minutes, almost 9 full minutes. Isn't that first-degree murder or intentional second-degree murder or something?
Oh, clearly, I think 8 minutes and 42 seconds is a long period of time. And you exacerbate that by the fact that the victim is saying, I can't breathe. The victim is clearly on the throes of imminent death. and nothing is being done, that's about as intentional as it gets. And as I said previously, you could say that that constitutes premeditation and deliberation. Now, why they charge second-degree murder and via the felony murder doctrine, I don't know. I think the Attorney General who took over this case, Keith Ellison, correctly stated that given past practice, it's very difficult to prosecute these cases. As Professor Tibbs has mentioned, there was an acquittal in the Castile case. And that was that's probably perhaps accounts for their reluctance to go a little bit higher, given the clear indication that there was intent in this case, if not actual premeditation and deliberation. That's the only supposition that I can surmise at this point as to why you don't have a charge of intent. And perhaps, like I said previously, the prosecution may have felt, the Attorney General may have felt that proof via the felony murder statute, given the mens rea for murder, would not have to be established, or intent would have to be established, but rather using the predicate underlying felony as the basis for the charge might be an easier way to obtain a conviction versus the traditional means.
I think that the reason I assumed it was chosen was the penalty is the same as intentional second-degree murder, but with one less element to prove, that intent. On the other hand, this is an intent crime. People shouldn't think it's not. Because felony murder, as everybody knows, involves the commission of a felony. Now, this is an unusual felony here to be included under felony murder. Usually, there's a list of very dangerous felonies, and this is subject, aggravated assault would not be the underlying felony because of the merger rule, but apparently that's been abrogated in Minnesota. Anyway, but there is an intent requirement. It's with regard to the felony, the underlying felony of aggravated assault. Interestingly, aggravated assault defines itself as a really bad assault. You go to assault doesn't say anything about intent. But we read into the law, the court will read into the law it won't, assault won't be a strict liability offense. There'll need to be intent. So intent has to be proved close to the intent of murder, the intent to do great bodily harm. So it's not much of a difference. It's not much of an advantage. And, but I think it's perhaps that intent is a slightly easier obstacle to get over than the intent to kill. I would imagine that's the reasoning.
Mm-hmm.
And I would say, Dean Lawson, if I was to give this fact scenario to my students on an exam, I would expect that they would charge with an intentional homicide here. It seems that we have all the facts that are present to support intentionality. It seems that the time frame is enough to support premeditation. And we know that the court is very clear about it doesn't take a whole lot of time to premeditate. There is no sort of time standard, there's no factor, there's no numerical value on how long you have to think and deliberate before it actually officially becomes premeditation. So I think sort of giving the length of the time frame for subduing Mr. Floyd, and then the amount of time frame that the Officer Chauvin, continued to keep his knee on his neck, even though he was no longer breathing, in addition to the fact that he was told to get off of him and said, no, I'm going to still continue to hold him down. That in and of itself constitutes intentionality from my perspective.
You know, one thing that I haven't heard anyone talk about, and we just leave it for food for thought, that everyone is identifying this as somewhat a racialized crime, but there has been no allegation of hate crime in this case. Is there a reason for that, do we think? Anyone? We can move on. But I just wanted to highlight, if we're circling around, this is an issue of racialized systematic racism in the police department, and maybe that's what the human rights charge is trying to get at. We'll have to see what the investigation produces. It doesn't seem like there's been much discussion of whether this is a hate crime or not, which we know statistically is a very undercharged crime because of the additional element, as Professor Silver was pointing out. Prosecutors like the offenses that have fewer elements because that, the burden is high, proof beyond a reasonable doubt. They would have to prove motive of racial animus. An interesting additional fact we haven't talked about here is this was maybe not a stranger case. This was maybe a case where this officer knew George Floyd from prior working relationships and had a beef with him. So that would also potentially fold in to the intent and when it was formed, and that it was intentional as opposed to accidental or reckless, or just strictly liable during the course and furtherance of an existing felony contact. But I really want the experts' opinions on where should the students, particularly the students in our audience, be focused as it relates to reform efforts. Where do you think the most value is in reform? And we've talked about unions, we've talked about statutes. Are there things that we can do, that students can research and propose, that would help this situation?
Well, from what I've heard from reports, I guess maybe we should look at Camden, New Jersey, where the community policing model has really been implemented to its true and fullest extent and degree. And at least from the reports that I've seen, I haven't delved into it thoroughly, it seems to me that if Camden can institute a policing model that shifts away from that need, that overriding emphasis on force, but rather on becoming a full and vibrant part of that community, that perhaps that's one way that you can start, as well as giving teeth to civilian oversight boards, the national databases on excessive uses of force by police officers, so that we know the folks who are doing that. Those are just some of the ways in which we can try to see how to reform the system. But from all accounts, it looks like Camden, New Jersey stands, from the reports I've seen, as a model.
I would invite students to, anybody who wants to, join me. I'm trying to come up with a statute, a state statute for all states that would entertain this, whereby the idea of the appointment of an independent prosecutor to remove this, what I believe is a structural conflict of interest, when we ask them to charge police in the same district that they, where they're basically vocational family members, the appointment of an independent prosecutor through some sort of commission. And that's the devil there is in the details. And if any students want to help me work something out like that to be proposed to legislatures, that would be great. My email, you got my email address, so feel free.
And to Professor Garcia's point, who would have thought that we would say that Camden, New Jersey is the model for policing, right? I mean, I lived on the other side of the bridge from Camden, New Jersey, and for 11 years. And I'm just here to tell you, if Camden, New Jersey can successfully change policing, anybody in this country can. That certainly is a model that I agree that we should be looking at. And I think, one of the things that I'm going to be working on in the immediate future is to deal with this issue regarding immunity. I just think that there's time for a move in America for us to start really being more fortuitive about how we deal with accountability across the board for everything and for everybody, and for the police to sort of operate in a space where they can do anything, anytime, and never have to face any accountability is just a growing issue. And until we wipe out and get rid of that qualified immunity standard that the police use as both a shield and a sword in terms of their protection, it's going to be hard for us nationally to move forward to a space where there's going to be more accountability. So to add to Professor Silver's points, if you want to work on issues related to immunity, dismantling qualified immunity, those will be the issues that I'll be working on in the immediate future.
And I would add in my professor capacity that I would think something that relates to raising awareness of the problem. Yes, we've seen these videos and they're horrific videos, but we keep seeing new videos. We saw horrific videos prior to George Floyd's death. And we as a collective community need to do something, agree together that this is not going to continue. One of the things that I've written about and highlight, where we've had under enforcement of law, the community has come together and demanded that the neglection of that area no longer continue. And I think one that we could remember and relate to was Mothers Against Drunk Driving. Do you remember that? That drunk driving was always a crime. It was never lawful to drive recklessly and intoxicated, but it was socially acceptable for the most part. You thought you're just a little tipsy, you can make it home. And Mothers Against Drunk Driving changed the collective consciousness on whether it was okay for someone to drive tipsy and then kill people, accidentally, and it raised our understanding of how serious a harm was being created in our community, such that we stop each other. Hey, don't drive drunk, take an Uber, leave your keys at home, I'll give you a ride. Even restaurants and establishments start paying for, those cabs home for everybody, not just the people they had to kick out because they were too drunk. So that's my vision of us as a community. I know we're in a moment where people are pointing to certain leaders, and that's good, and certain corporations and certain institutions. But we all know from history, the only way we change is each of us changes how we think and how we see things and how we address the humanity of each other, because this case is really a human dignity case at the end of the day. And race is involved. We've outlined that, and the statistics prove that, and criminal law statistics have shown the race of the victim is the most significant factor in a criminal case. It drives how serious the charges are going to be, and it drives how serious the punishment is going to be, until we require a change. And I just call on all the audience, the students, the alumni, the lawyers, to work, that we can work collectively on all these areas of reform and individually to make a difference in our community, to end this type of issue, that we won't have to gather and talk about this anymore. But as a law school, I thank you. As a law school, we will continue to engage in these important issues. We will continue to publish scholarship on these important issues. Specifically, we also have opportunities for students to publish their work, which is unique in our Symposium issue. And this is just the beginning of our conversation. This is our first panel and lecture. We have many more to come. including the international aspects, hearing from the police and the prosecutors, and hearing from attorneys who are representing cases like this on the front lines. Our first attorney that is confirmed is the attorney for Breonna Taylor, and she's going to share with us the issues in that case, which are a totally different type of case. Execution of a warrant in someone's home, which led to the unfortunate killing of Breonna Taylor in her bed. So these are issues of criminal justice, criminal law, criminal procedure that we as lawyers are willing to tackle. And I just thank you for your time and attention. I thank the faculty, our expert panel, for sharing your knowledge and expertise and continuing to work with our law community on these important matters.
Thank you, Dean.
Thank you.
Thank you very much.
And this adjourns our panel for today. And thank you.